All right, we're gonna go on the record and state, I realize you were not expecting to be here, so your address is excused, that's fine. So we're going on the record in 2024 CR 0735, State of Texas versus Claudia Aaron. Could I have the parties announced for the record for the state?
Daniel wants to walk for the state of Texas.
Defense?
Christian Vega for the defense.
All right, you're here for a bond?
Yes, Your Honor. Elizabeth Russell, attorney of record, had filed a motion to set bond.
Well, let me ask you this. Because previously I had the attorney of record as Jody Sawyer. Has she filed a motion to withdraw?
I believe there was a motion to withdraw, and then Elizabeth filed into the case.
Well, no, I mean, has it been signed?
That is my understanding, Judge. I don't know if that's what reflects on.
All right, so we'll need to find if that's done, because if that has not been done, then Jody Sawyers is still the attorney. So let's figure that out first.
Yes, Judge.
And I'll see if I can look up on my system.
You see if that's on us. Good to see you, Judge.
You too?
Yeah, showing that Elizabeth is the attorney of record. Judge, is it okay if I sit?
Yes, it's okay.
Okay. Judge, Elizabeth Russell was appointed on July 17th.
No, but she may have been appointed, but her retained attorney was Jody Sawyers. So unless Jody Sawyers filed a motion to withdraw, then she is still the attorney. And unless that motion to withdraw was signed, she's still the attorney. So my question is, has a motion to withdraw been signed? If not, she's the attorney. And you're saying that Elizabeth Russell was appointed?
Yes, I believe after that motion was granted.
All right, so the first question is whether or not that motion was granted. Because if that motion has not been granted, then that is her attorney. All right, so what I do know from my memory, what I do know is that Ms. Sawyers at first wanted to be withdrawn from the case because she said she was having issues with Ms. Aaron's father interfering with her ability to represent her. However, that motion was never signed because where we left off was the father gave Ms. Sawyers, Ms. Aaron's medical records. And then after that, Ms. Sawyers never asked that the motion to withdraw be heard again. So Ms. Sawyers is her attorney. And if somebody has appointed an attorney, then that's interfering and that's unethical to appoint an attorney when she has a hired attorney.
I think that might be the confusion here, Judge. It seems like the dates where she filed this motion on 7/2, and then Elizabeth Russell was appointed after that without any substitution. So she.
And there can't be a substitution when an attorney has been retained and manager signed counsel. I'm assuming manager signed counsel appointed somebody, or?
I'm not sure, Judge.
All right, so then Jody Sawyers is the attorney of record.
Okay.
So if you want to get in touch with Jody Sawyers and have her here, and then somebody else needs to find out if she's retaining a counsel, then how is she qualified for a court-appointed attorney? Those are issues that need to be addressed unless we're just giving everybody a court-appointed attorney, whether or not they can afford one.
I'll look into
These
that.
are just questions the court has.
I understand, Judge, and I can look into that. For efficiency, Mr. Escobar has indicated that, he'll defer to your judgment on this issue of whether or not she's.
Oh, state's attorney will need to be here.
Okay.
All right.
All right.
Okay, so I'll be here all day.
Okay, Judge. Good, Judge.
So if you all want to get in touch with Jody Sawyers, you can.
We will. Thank you, Judge.
Okay, you're good. And you can talk to her when they bring her out. Here's the issue. She retained an attorney. That attorney did not have a motion to withdraw signed. She's still the attorney. And what ended up happening at that hearing is there was an issue where the defense attorney said that the father of her client is interfering with her ability to represent her. But the father ended up turning over medical documentation to the defense attorney. And then that was that. There was no re-urging of the motion to withdraw. And there's nothing in the system that shows, one, that a motion to withdraw has been signed. So if a motion to withdraw has not been signed, that's still the attorney. And correct me if I'm wrong, for the MAC to appoint her an attorney while she has a retained attorney in felony court, that appears that may be interfering with the attorney-client relationship. And then the next questions become, if she was able to afford to hire an attorney, then why is she receiving appointed attorney, a court-appointed counsel? So if you wish to speak to her, you can. But what I can tell parties is I am not proceeding unless Ms. Sawyers appears, because she's listed as her attorney of record.
May I address the court?
I mean, no, that's what I've said. So if I'm not proceeding without Attorney Sawyers being here, because technically that is her client. And I haven't received a motion to withdraw.
Have, and it's on file.
It hasn't been signed.
The order, you're correct. The motion has been signed by Ms. Sawyers. The order has not been signed, but there's a YouTube video in which your court said that as soon as Ms. Aaron reappeared, you would sign the order. She's here. So we're requesting that you sign the order.
Ms. Sawyer needs to be here.
She is in a jury trial for several days. So you're saying Ms. Aaron is going to have
a seat
and
Have a seat. Thank
Okay.
you. All right, so I'm going to proceed with this hearing. Excuse me, I don't understand the attitude. Have a seat. I will take your matter up. I was explaining to you what the issues were. I don't know why people don't understand what I'm saying. I've explained to you what the issues are. You see these attorneys sitting here. I was giving you all opportunity to speak to her so you can understand what the court's issues are. That's where we are.
Judge,
And then I'm going to take this hearing up, and then we'll continue with your matter.
I'm not the court-appointed attorney, as you've already mentioned. So
No,
I'll
you're not.
contact Ms. Sawyers.
Thank you. Have you seen the motion that the defense attorney filed? It's not a proper motion. It doesn't say anything. So
We're requesting, and I've got pre-trial, we can get her screened for indigency.
Okay.
We're on standby, we can take her out. She can't be downstairs, we can have one of them come up here and screen.
all right, so shouldn't she be screened for indigency before you all represent her on the PR bond?
Good.
I mean, I think that's the proper way.
She just got her judge, so I can get with pre-trial and have them come up. I talked to the
All right, so if you'll get them to screen her, but what we'll do is, Attorney Sawyers, we'll hear your motion to withdraw. Someone from the state is coming down right now, so we'll hear your motion to withdraw. And if that motion is granted, then if you could go ahead and have someone screen her to see if she's indigent. And then if it's determined that she's indigent, then you all can appoint somebody, and then I can hear whatever motion you all want to hear. And what Attorney Elizabeth Russell's, this motion for a PR bond is not in the proper format. It doesn't have the proper, it's not presented legally, should I say. So I'm sure the state will have no objection to your doing it orally. Sure. All
Just
right,
to clarify your,
yes.
just to clarify, you said the defense motion. Are you talking about that motion about the PR bond, or my motion to withdraw
Your motion to withdraw.
was not done properly?
No.
Oh.
Elizabeth Russell filed a motion for a PR bond, and it's not legally before the court. So this is what ended up happening, Attorney Sawyers. You filed a motion to withdraw. There was an issue with Miss Aaron's father interfering in your representation. When we were here the last time, he came forward, tried to be an attorney, and then he handed to his daughter her medical records, which she then handed to you. And then the motion to withdraw wasn't taken up because I think assumptions were made that he wasn't going to interfere with your representation. Then she didn't show up for court, even though she had noticed to be in court. And so a bond forfeiture was issued, and the court said that I would take up your motion to withdraw once she was in custody. And so that's where we are. So in between that time, managed to sign counsel, appointed her attorney, which technically is unethical because you are currently the attorney. And so that was interfering with the attorney-client relationship with her. So what we're going to do is, if you still wish to withdraw, I'll hear your motion to withdraw. Once I've heard your motion to withdraw, if I grant it, and part of my granting is going to depend on whether or not Ms. Aaron has any objection to your withdrawal. If I grant it, then you will be excused, and then they will have someone interview her for indigency, because that was not done either before an attorney was appointed. So that's where we are. So the state is coming down. I'll hear your motion to withdraw.
And just so that the court is aware, I had thought that this had already been granted because Elizabeth Russell reached out to me. And so I apologize for the confusion. I did not realize that I was still on the case. I had met with Elizabeth and, well, over the phone, we had a teleconference, but provided her a briefing of the case at her representation to me that she was appointed to the case. So I have communicated with her, and the only reason I wasn't there yesterday is because I didn't realize I was still the attorney of record.
No, it's absolutely not your fault. So that's fine.
I just didn't want you to think that I was intentionally not showing up. I guess it was just a miscommunication, and I do apologize.
Apology accepted, but not needed. I understand things happen. You've never before not appeared before court, and you've always been respectful. And I'm assuming you still wish to withdraw. Is that correct?
I think at this point it should proceed, but obviously I haven't spoken with Claudia because I thought it had already been granted at her request.
All right. Do you wish to still withdraw or no?
I do wish to withdraw, but I need to hear what her position is, obviously, because I haven't revisited the conversation since I was asked to withdraw the first time.
All right. Just give us one moment, okay? All right. Are the parties ready to proceed?
We are, Your Honor.
All right. And are you still going to be asking to withdraw?
I am, by agreement of the client.
Okay. All right. Court is, I'm sorry, Ms. Guthrie, are you ready?
Yes, Judge.
All right. Court is calling 2024 CR 0735, State of Texas versus Claudia Michelle Aaron. If y'all will come forward. Now, have parties announced for the record for the state.
Daniel Escobar for the state of Texas.
And for the defense.
Jody Sawyers.
All right. And are you Miss Aaron?
Yes, ma'am.
All right. Ms. Sawyers has filed a motion to withdraw. State, do you have any objections to that motion to withdraw?
No, Judge.
And do you have an objection to Ms. Sawyer appearing by Zoom?
No, Judge.
All right. Ms. Aaron, do you have any objection to Ms. Sawyer's appearing by Zoom?
No, Your Honor.
All right. Do you have any objection to her withdrawing?
No, Your Honor.
All right. And Ms. Sawyers, what are your grounds for seeking to withdraw?
Yes, inability to communicate effectively and breach of attorney-client contract.
Right. And that ability to communicate effectively, is that due in part to Ms. Aaron's father?
In part, yes, but not in whole.
Okay. All right. Then the motion to withdraw will be granted to the clerk. Could you call her motion to withdraw for me, please? All right, then you are excused. Thank you, Ms. Sawyers.
Thank you, Your Honor. Have a good day.
All right, you too. All right, so the next thing that needs to happen is then she needs to see, we need to see if she's indigent or not.
Yes.
And
Judge, I have pretrials on their way up here and we're having her screen through 1702.
all right, thank you. And how long would that take?
I'm assuming it shouldn't take more than 10 or 15 minutes once they get here.
All right. All right, go on the record. Court is again calling 2024 CR 0735, State of Texas versus Claudia Aaron. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Renee Munoz.
And are you Miss Aaron?
Yes, Your Honor.
All right, and we do have the court reporter by Zoom. I'm assuming nobody has any objection to the court reporter appearing by Zoom?
No, Your Honor.
No objection from the defense.
All right, Mr. Munoz, you have an oral motion?
Yes, Judge, if I may, with the court's permission, we're asking for a PR bond, personal recognizance bond. Judge, in this matter, it's my understanding, she does not have a lengthy criminal history. She's of a young age, and it's a nonviolent offense, Judge.
All right, state?
No objection, Judge.
Now we need to address the drug issues. Miss Aaron, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand, state your name for the record.
Claudia Aaron.
All right, I'm going to ask you some questions. It's not about this case. So, in the past, and I know it potentially could be current, but for purposes of this case and not getting into the facts of this case, I'm going to ask you about past. So what is your past usage as it relates to drugs?
I started consuming at a very young age to help deal with my mental health.
Okay.
Around the age of 13, I first started consuming
And what did you consume?
marijuana, and it led up to Xanax abuse and stimulant abuse,
And what type of stimulants?
cocaine and methamphetamines.
And have you ever had a mental health diagnosis?
Yes, yeah.
And what is your diagnosis?
Major depressive disorder, PTSD, and generalized anxiety.
All right. And with regards to, I'm sorry, any other questions?
No, Judge.
Okay. And do you have private insurance or no?
Yes, I do now.
Okay. And with regards to this case and the facts in this case, was there anyone else with her? Does anyone know?
No, Judge.
No one was with her?
No, Judge.
So she was by herself?
Yes, sir.
Okay. All right. It appears to the court that she needs inpatient treatment.
Your
Does she
Honor,
have?
with respect to that, we would ask if she could be scheduled for an interview for potential outpatient first, Judge. It's our understanding that outpatient is a less restrictive setting, and I've done with specialty courts for a little bit, and I've seen the case managers and the judges in those specialty courts talk about starting off with the least restrictive means, and if that doesn't work, to move up to more restrictive means. Namely because if she doesn't need, particularly the assessment doesn't reflect her needing the inpatient, and she goes in there, it could be more damaging than her starting in at a less restrictive. So I'm asking if we can get her evaluated to see her level of needs. I'm not a social worker or LCDC or master social worker, Judge, so we're just asking for just her to be vetted through that to see what she may need from a licensed professional. I don't purport to say that I'm a physician or I know anything about chemical dependency use. I try to learn and absorb as much as I can, Judge, but I think that's why the professionals are hopefully there to
All right. Have you been into inpatient treatment before?
Yes, I currently went on June 22nd of this year.
Mhm.
I've been clean off of hard substances since December 1st of 2023, and I've been sober from alcohol since June 23rd of this year.
All right. So you said you went in inpatient on June 22nd.
Yes, Your Honor.
When were you released from inpatient?
I was released on Monday.
So do you feel you need to go back to that facility?
No, Your Honor.
All right. And when you say you were released, did the persons at that facility release you?
Yes, and they have me in intensive outpatient programming at the moment.
All right. And who is that with?
It's with Windmill Wellness Ranch.
And what does that outpatient treatment look like?
It's 3 days a week. Any days I'd like from 9 o'clock to 12 o'clock for the next 4 weeks.
And what do they do?
We specialize on processing emotions and just constant drug testing and just kind of regulating me back to a normal lifestyle instead of like a heavy, intensive inpatient program.
And how often are they doing drug testing?
At the moment, I have one. I don't know how often they'll be doing it for the next 4 weeks.
All right. And this outpatient treatment, how long is it?
It's for the next 4 weeks.
And what if you need more treatment in outpatient than that? Have they given you an idea of what they would do?
Yeah, I could definitely always ask for more time and help if I really am struggling and need it.
All right. Any other questions?
So, just one brief question, Judge,
Yes.
so Ms. Aaron. Upon you, if you're able to be released on your own personal recognizance, upon you don't have to pay, would you be re-entering that substance facility, the outpatient to get help?
Yes,
And that would be for when again?
the next 4 weeks.
Okay, no further questions.
All right. This is what the court is going to do. The court is going to order outpatient treatment with Windmill Wellness Ranch, and that's through your insurance.
Yes.
And so what I'm going to say then is to be paid by Miss Aaron. If for some reason something happens with your insurance, let your attorney know, come back to court, and we'll do a different outpatient treatment.
Okay.
And counsel, she's going to have to do a release to pretrial services so they can make sure that she's actually attending.
Okay, yes, Judge, no problem.
All right, so there's going to be outpatient treatment with Windmill Wellness Ranch. With treatment classes at a minimum of 3 days per week.
Yes, for 3 hours a day or for 4 weeks.
And there is going to be random UAs,
Yes.
and that is going to be, yes, I know wellness, they're doing their UAs, but these random UAs are going to be through pretrial services, and I'll ask that they waive fees.
Yes, Your Honor, thank you for that, and I'll explain that to her as well. Pretrial services aspect.
And then I'll ask for a referral to Center for Healthcare Services if she has a private provider with regards to that, then she can do private provider. So I'll say referral to Center for Healthcare Services or with a private provider.
Yes, Your Honor.
All right, is there anything else you need to be successful on this bond?
No, Your Honor.
Defense, is there anything else she needs?
Nothing further, Your Honor.
Okay. And let me just add one more thing. After conclusion of treatment with Wellness Ranch, I'm going to order 120 sober days. I'm sorry, 120 sober support meetings in 120 days. And I will tell you, those are NAAA meetings. Sometimes people are feeling a certain way about doing these. They're like, why do I have to do this? It's so much work. But then what I've discovered and what people have come back and told me is that once they get into the routine of going to those meetings, they really enjoy it because they get a chance to meet other people who are in the same situation that they're in. And then the next thing I know, they're doing retreats with them and it becomes a way of life. So it's going to be 120 sober support meetings in 120 days. All right, and then I'm going to set you to reappear in this court for this case. And let me look at my calendar. We're going to come back on October 7th.
Yes, Judge.
All right, is there anything else?
Nothing further from the defense, Judge. We appreciate your attention to this matter.
All right, and if y'all will have a B page pulled, because otherwise the fact that I've just said it on the record is not enough. It needs to be in writing. So if y'all will pull that for me and I'll put it in writing.
So I just go to the clerks in the back and ask for the B page, Judge, and they should be able to provide that?
Yes,
Okay, will do.
and I'll give you this reset form.
Yes, ma'am. And then I'll have
And-
her execute that as well.
All right, and this will be for discovery. Yeah, thank you. All right, thank you, Stephanie. We are done.
Okay, thank you, Judge.